Hey everyone, thank you for joining me today for another LinkedIn Live. If you've been here before, you know that I do these every last Wednesday of the month at 10:30 Eastern. You'll notice today is not the last Wednesday of the month. So while very excited about like lots of stuff going on with AI. So I am going probably twice a month for the near future. There may be times when I can't do the second Wednesday of the month, but also look out for lives on the second Wednesday of the month as well. But always the last Wednesday of the month, 10:30 Eastern. So also, just to let you know, this is being recorded. You can find the recording on my LinkedIn profile. Also, I have a YouTube channel for my business, Think Beyond IP. You can also find the recording there. And from time to time, I release it on LinkedIn Lives on my podcast, which is Scaling Expertise. Finally, I will talk for about 15 minutes to cover some of the topics I want to get through today. But please feel free to put your questions in the comment box at any time while I'm speaking. Do not wait until the end because there is a bit of a delay, surprisingly long when you're staring into the camera. So please feel free to put those comments in as soon as they come to you. So, with that, let's talk about AI and copyright infringement risks. So, most of you know that the key IP legal issue with respect to AI is a copyright issue. And that copyright, protects the owner of the copyright from other people literally copying their work, using it without permission. And so, the big issue with AI is that, you know, one, how the tools uh, may cause copyright infringement, both in connection with the input, the way they're using the input, and also with respect to the output. So there's on both sides of the black box that is AI, we have potential copyright infringement issues, which we'll talk about. And then we'll talk about some strategies to help you avoid that risk. So these are the main issues we're going to be talking about: the training data issues, unintentional replication, duplication, and also derivative works. So first, let's talk about the training data issues. So as something like a Chat GPT or Genesis or Claude, they have billions of points of data that they use to train that AI model. So there's lots and lots of data in there. There's some magic technology that helps it use it to provide answers to whatever prompts that you have, what you're asking of it. And so where could you get billions and billions of points of data? Well, you got it from scraping the internet. They literally, early versions of AI literally just scrape the internet. And so that would include scooping up lots of people's content. Obviously, you're not going to get billions of pieces of content by getting consent. And so those training data, that training data was acquired without the consent of the owners of that content. And so you may be aware of lots of litigation that is currently still in process. I have no idea how long it will take to resolve. I imagine they're trying to resolve it without it going to trial. But some of the bigger ones are the New York Times against, like AI, Meta, Anthropologic, I think is the name of the one that does Claude. All of them are being sued because the way they originally acquired their training data. And so the open AIs of the world, the AI platforms are saying, no, it wasn't copyright infringement because they're claiming a fair use argument. And, I hate talking about fair use because I don't want anyone to rely on fair use in order to use somebody else's content without permission. But basically, briefly, fair use is a defense against a claim of copyright infringement. There is no affirmative fair use right. It is a defense against a copyright claim. And so these AI platforms are saying that it was fair use to use all of this content because we just used it to train the data, but we're not actually like making copies of it and selling it. We just used it to train our technology. And so they're claiming that it's transformative. It's not that, not what copyright law was intended to protect. And so again, lots and lots of legal claims going on regarding that. That Authors Guild, a number of celebrities are also headlining a few of those claims as well. Music companies like Sony Music. So we will find out where the court comes down on whether or not using training data, using content as training data without permission is copyright infringement. Now, generally, we think about these input, like the training data problem, as being an AI platform problem. Like we're not scraping the internet. Like at least I hope you're not scraping the internet in order to create like this, your own AI platform. There are times when we may be in trouble from a training data perspective, even as individual business owners, and a couple of circumstances where that could happen. And obviously, this isn't um, a complete list. So, for instance, I have a custom chatbot on my website. Now, my chatbot is closed, so it only scrapes data from my website. It scrapes all of my blog posts, the other content, my podcast episodes, the transcripts from my podcast episodes. So, you can go to my website and ask it questions about anything I've written or talked about. But what if I had a chatbot that also was open up to third-party content, that I also, used it to connect to, the internet generally? This would obviously be a problem, but also maybe to, I spoke at a conference and I opened it up to the conference's content, like the organizer's content, because I also wanted to get access to that. Then I would be guilty of putting the training data that I'm getting from the content that I'm getting from that organization's website and using it as training data without consent. And so it could be a problem there where I'm creating that training data. The other place where it can show up is in the tools that we use all day, every day, without thinking about the fact that how we are using it is creating training data for that platform. I'll give you the example of ClickUp. So we use ClickUp in my business, and ClickUp has now added an AI function. And so if I have client data in ClickUp, and that ClickUp can access my client data and use it as training data for its product, I have now included content that I do not have permission to use as that ClickUp's training data. And that can happen in other ways. I always caution people about those AI note takers. Some use the transcripts as training data, so you really need to be careful about that. I note that Adobe has an AI assistant, so you can upload something into Adobe, a PDF, and use their AI assistant, and they can read a contract and give you a summary of it. And so I happen to know that Adobe does not use that as training data, but there are others that might. That's an example of where you might be uploading something into a tool that you're using, and that platform is using it as training data without your client's permission. So those are a couple of ways that can happen. In addition, so let's just say that the courts find that the way OpenAI has scraped the internet, that's fair use. I don't think I'm not going to say what I think. Let's just say that they do. So even if it is considered fair use, we still have the issue of the output. So is the output a copyright infringement? Because what can happen is that what comes out is essentially a copy of the original training data. And I'm going to flip briefly to an example here. Hope you guys can see it well enough. I mean, at least the color differences you can see here on the left is what the output from ChatGPT was. And here on the right was the actual text from the New York Times article. And you can see from this contrast that ChatGPT essentially copied the New York Times article and spit it out. So clearly, using that output would be a copyright infringement of the New York Times article. And so, you know, OpenAI, said, well, wow, if you give enough detailed instructions to the chat, that it might, you know, uh, cause it to have an output that's essentially the same as the original article. And if you were going to do that anyway, why wouldn't you just go to the original article anyway? Like, but so I don't know exactly what the prompt is, but they do make a big deal about how detailed the prompt was in order to kind of force this result. But it is possible that chat has scraped up something where there really is only one source about the topic, and you happen to ask about that topic, and so it brings its output is very similar to what the input was. Even if that input was fair use, that output would be copyright infringement. So we need to be careful about the output. And then finally, even if it isn't, an virtually exact copy like in this example, it could be that it's considered a derivative work. So what is a derivative work? So under US copyright law, the owner of that copyrighted work also has exclusive rights to create additional works that are based on the original work. Think about turning a book into a movie. That movie would be considered a derivative of the book, and only the copyright author can consent to their book being made into a movie. Lots of issues regarding sampling with music, from the 80s now, I think it was. And so, what if it's not the exact replica, but it would be considered a derivative? So that derivative also would be considered copyright infringement if it is done without consent. So those are the main issues regarding copyright infringement. So now let's talk about what we can do to try to avoid getting into this trouble. So first of all, we have to, be really, I mean, there are lots of reasons why we want to be careful about how we use output. This discussion doesn't cover hallucinations and accuracy. So let's just assume it's accurate. But in order to avoid infringement risks, we need to make sure we are double checking that output. So there are some tools that you can use, Grammarly, and I have a list of them here. Hold on. Grammarly, Copyscape, Plage Scan. So these are essentially looking for plagiarism, but also can be used to look for copyright infringement. Obviously, when you use these tools, they're not going to guarantee that if they don't find plagiarism, that it is clear for against copyright infringement. Obviously, they're not going to give you legal advice, because that would be legal advice. But you want to make sure that if you have asked Chat GPT or something similar, Claude, to write an article for you about how to lead new, create unity among new team members, and they write an article for you, that you are checking it against one of these tools to make sure it literally wasn't a duplicate or perhaps a derivative. We want to make sure that that is clear. Also, make sure you read your terms of use for the platform. For example, for Otter, people love to use Otter. People show up with Otter AI into my consultations, and I say, no, thank you. Because when you read those terms of use, Otter's terms of use will say that we use the content as training data. So what's being transcribed is being used as training data. And so there are some like Fathom and AI Companion that do not use that conversation as training data. So make sure you are reading your terms of use for any platforms you're using. And that also goes to the other things like the ones I mentioned before, like ClickUp and Adobe and things like that, things that you're using as kind of ordinary productivity tools. You're not even thinking about them as AI tools, and make sure when they add AI functionality, the reason I'm even using ClickUp is because recently I got an email from them saying, "Hey, we added AI." And great, so what does it mean to how you're using all the stuff I have stored in my ClickUp account? So you want to make sure you're keeping up with that as well. Making sure that you have AI usage policies. So you want to know, like, based on how you're going to be using the content, both the input and the output. Is it confidential information? Will you be using it to create a client deliverable? Will you be publishing it? Or is it something you're creating that's an evergreen that you want to, own the rights to? Is it, all these things will determine when and how and which AI tool to use. So you want to have some guidelines about that. If you're just creating you're taking something and creating some social media posts that are, 50 word long and they come and they go and no one ever pays any attention to them, you don't have to worry about these so much. But again, if you're using it to create, some a course or, a chapter in a book, people use it to write books, then you need to be really careful about what you're doing. And of course, if any sensitive information is being used, you need to be really careful as well. And then finally, stay up to date. Lots of things are happening. Those court cases, should they ever be resolved or settled, that will also may affect how we use AI going forward. And please, stay connected with me. If you aren't already connected, then please do, since I will continue to do LinkedIn Lives about different AI issues and the legal and ethical obligations that we have when we're using it. So with that, find me again here the last Wednesday of the month for another AI topic. I will send out a notice about what it will be about a week ahead of time. And so I didn't get any questions, so thank you so much. I'll see you next time.